Good morning. The February 24th, 2016 meeting of the Board of Investment is now called to order. In the interest of promoting the order and efficiency of these hearings, persons who are disruptive to the hearing will be asked to leave the hearing room immediately. Meetings of the Board of Investments are open to the public for the duration of the meeting. The hearing room must be vacated at the conclusion of the meeting. Failure to comply may result in a charge of trespassing. Madam Deputy Controller, are there any corrections, additions, or deferrals on the agenda?
Good morning. For today's agenda, the board received the protests for pages 89 to 90 from the Upton Historic Marble Hill Preservation Compliance Board. That item will be deferred for 1 week, so the protest will not be heard. In addition, the board received for pages 98 to 99 for items 5 and 6 a restated notice of the withdrawal of the bid of AM Liner and the intended protests on behalf of AM Liner by Herschler Fleischer if the board makes an award on that particular item. The board also received the protests from Ms. Kim Trueheart for all items on the agenda appearing on pages 1 to 121. The board did review her protest, however, it will not be heard. We have one item that is being deferred, and that is pages 89 to 90, as mentioned previously, for 1 week. As a result of the correspondence on behalf of AM Liner, we're also moving to the non-routine agenda, pages 98 to 99, number 5 and 6, as well as remain on that non-routine agenda, pages 97 to 98, items 3 and 4. I have the following abstentions and no votes to report. The Honorable President Young will abstain on page 58. Pages 109 to 110, items 12 and 13. Also, the Honorable President Young will vote no on page 26, page 66, page 67, pages 78 to 79, and pages 80 to 81. The Honorable Comptroller Pratt will abstain on page 4, page 23, item 1 for LE Blue only, page 42, item 14, page 96, item 1, page 108, item 8, page 108, item 9, and page 109, item number 10. In the absence of Mr. Rudolph Child, Ms. Dale Thompson will sit and act on his behalf today. The items that remain on the non-routine agenda are pages 97 to 98, items 3 and 4, and the item that was moved to the non-routine agenda, page 98 to 99, items 5 and 6. Mr. President, members of the board, those are the protests received, the one item being deferred, the abstentions and no votes that have been reported, as well as the items on the non-routine agenda. Thank you.
Thank you. I would direct the board members' attention to the memorandum from my office dated February 22nd, 2016, identifying matters to be considered as routine agenda items together with any correction and additions that have been noted by the Deputy Controller. I will entertain a motion to approve all of the items contained on the routine agenda.
Move approval of all items on the routine agenda.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carried. The routine agenda has been adopted. The first item on the non-routine agenda can be found on pages 97 to 98, items 3 and 4, recommendation for contract awards and rejection, WC 1342, urgent need, metering infrastructure repair and replacement, various locations. Will the parties please come forward?
Good morning, Madam Mayor. Good morning, Council President, members of the board. My name is Art Shapiro. I'm representing the Department of Public Works, the Chief of Office of Engineering and Construction, and presenting contract WC 1342, which is an urgent need on-call contract for repairs to water meter vaults and services. These repairs are required in order to support the ongoing Baltimore project. The bids were received from 3 firms. Low bid, lowest responsible bid was from Spinello Construction at $5.853,375. The second low bid was from Harrington at $7,094,950, and Metra was the third low bid at $7,632,225. The bids, the low bid was 42% below the engineer's estimate. We recommend that the award be made to Spinello.
Okay. Good morning.
Good morning.
You got talking to Mike.
Apologies. Good morning, members of the board, President Young, Madam Comptroller. I'm here on behalf of Metra. Neil Duke, for the record, on behalf of Metra Industries. Also with me is the Vice President of Metra Industries, Mr. Robert DePonte.
Okay.
Do we want to go?
Either or, it's up to you all.
Well, that's fine.
Sure.
I'll be happy to go. Mr. President, good morning, members of the Board of Estimates. Good morning. My name is Edward Smith, Jr. I am qualified as a person to represent R.E. Harrington. Mr. Harrington, President of R.E. Harrington, is here today. We have filed our written protest, of course, pursuant to your rules, and we're going to ask, and I know this may be somewhat controversial, however, we're going to ask up front, Mr. President, that the member, specifically the member who is on this side of the table, the city solicitor, as well as the deputy director of DPW, be excused from participation in this matter. As you know, we raised a conflict of interest as to Spinello and Itron in our papers. We believe, and we have requested under the Freedom of Information Act, that any information given to DPW, Mr. Chow, who asked, in our belief, the city solicitor's office to give him an opinion as to whether or not there was, in fact, a conflict of interest, as we have set it forth in our papers. We believe that we have not received that information, first of all, when we made the request just the other day. And that is, we believe that there was, in fact, a document which shows that there was a direct conflict of interest between Itron and Spinello in this particular contract. Moreover, we believe that under your edict and under the way that you conduct your business, dated in your memorandum of understanding of February 15th, I believe, of 2015, 14, that you would be permitted to move that both of these individuals who have a conflict be excused from determining any aspect of this case. We think that the DPW director has direct knowledge of a conflict, and we think that because they received the information from the city solicitor's office, that he should be barred as well from making any determination as to this particular bid. Now, the reason that we say that is historical, and obviously there have been many tricks that have gone on before this board as it relates to contractors who both, one, come from out of town, and two, who have decided that they should have the benefit of the money that our taxpayers pay in order to bring these projects. And we would ask you, Mr. President, to consider this very carefully because we have an opportunity here to stop this historical bleeding of our community. And it needs to stop here and now as a signpost to others who would come here in the future who would try the same tricks that have been played on this community for years. Mr. Harrington is a minority member of this community and a contractor of some note who has put his interest into this community. There are people who have families in this community that Mr. Harrington employs, and to allow the monies of taxpayers to continuously be sent out of this state and out of this city is the same thing that happened to us as a result of Freddie Gray. People who are sick and tired of being sick and tired that they can't get jobs as a result of what is going on here before this board. And I do believe that somebody has to stand up and somebody has to look these people in the eye and has to say what is wrong. The next political people who come in here after the next election should understand that this will no longer be tolerated. We believe that under the circumstances, it would be derelict of duty for this contract to be let as it is right now. And we do believe that Mr. Harrington, as the next lowest bidder, will not waste the assets of this city, will not allow this thing to go on as it has gone on for years. And I know that everybody in here knows what I'm talking about. I've been around for a long time, as many people in this room, and I stand, I believe, on the principle that we should not have disinformation. We should have what is right and what is proper, and what is going on here and what has gone on here is not right, nor is it proper, nor is it moral, nor can it ever be. Thank you very much, Mr. President.
Thank you. You have a question?
Yeah.
Use the mic.
Mr. Nielsen, could you state simply why it is not a conflict?
Well, which alleged conflict are you asking about, Madam Comptroller? If you're asking about the conflict that has been alleged with regard to the city solicitor and the law department, I gather it is based on the fact that we have been asked by DPW for our advice. It may also be based on the fact that Mr. Smith has filed a Public Information Act request and is seeking documents, and that's being handled by somebody in the law department. If the city solicitor could never sit in a Board of Estimates hearing or a matter where somebody in his office had rendered advice to the agency or in some fashion in the lead up, the city solicitor could never vote. So, I mean, I think it's absurd to say that there's a conflict as far as I'm concerned because the law department has been rendering advice as it always does. Now, if the question is, Madam Comptroller, if your question pertains to is there a conflict with regard to Spiniello?
Yes, that's the question.
I think should be answered by DPW because it involves an assessment of the facts on the ground, the circumstances and nature of the contract, and I think that question is best directed to Mr. Shapiro, and Mr. Mullen may be with him.
Yes, that's a conflict I was talking about.
Okay. Madam Controller, if I may, the claims in the protest refer to several issues, primarily a claim of conflict of interest. That claim referred to the claim that Spinello, by virtue of its involvement with the Itron contract as a sub, that they had some sort of knowledge that would have given them some sort of advantage in the bidding process. Our evaluation of the current process is clear that there is no such conflict. Another detail in the claim was that Spinello would, if awarded, be in a position to refer work from its involvement in Itron as a sub to itself as the on-call contractor. That's not true. The city has a very robust process between the Itron contract and the on-call contract by virtue of another agency, another entity that reviews all work referred by the Itron sub and makes a determination before any of that work is referred directly to the on-call contractor, not by Itron, not by Spinello, but by the city's third party to its on-call contractor. The bid documents that were provided do not have any prohibition for any contractor who may be working for Itron to prohibit them from bidding on other contracts. The same goes for the contract itself. 1342 does not have any prohibition preventing a subcontractor working for the Itron contract from bidding on the on-call contract because of the in-place quality assurance program. There was another claim that was made that Spinello could have some incentive to delay the work in some way in order to create a cost for the city by virtue of a delay claim from Itron. But we find that there's no incentive for that to happen. The contract 1342 has a requirement that work that's dispatched to the on-call contract be executed very promptly, within a week of it being assigned out. The Itron contract does not incur delays unless a delay extends for 6 months. So by definition, the on-call contract has a much shorter time constraint on it for execution. And there's no incentive that we can see for any contractor to delay its work in a short period in order to gain advantage or give some sort of advantage to Itron by virtue of a delay claim. They would be in breach much sooner than any kind of delay that would be incurred by Itron.
Okay, Ms. You finish?
Yes.
If I could, again, Neil Duke on behalf of Metro Industries. I'll keep things brief. The testimony by Mr. Shapiro and Mullen, I think, points out one of the challenges that this board should consider, namely that the bid from the successful bidder, Spinello, came in at 42% below estimate. Now, that may be a bright, shiny object that one may think you're getting the benefit of the bargain, but if you look at the spread of the actual bids that came in, it should cause any reasonable person to really question what's going on. You have from 5.8 million to 7 million to 7.6 million, and then there are two other bidders, it's my understanding, both of them came in at around $10 million. So the question is, what accounts for this spread? And we would suggest, based on those 5 bids, we have 2 contracts, water contracts at issue. 1342, which is the larger contract that deals with the smart meter installation here in Baltimore City and certain parts of the county. And then you have 1223, which is this particular contract, water contract, in which the bid protest is related to. We think, and I think the facts would bear out, that there are 2 certain issues. One, the conflict of interest that Spinello has by virtue of their relationship and association with Itron in the 1342 contract, and also with respect to the invitation for bid, that they had a distinct unfair advantage in putting together their invitation for bid. So ultimately, there are 3 things I think we're going to ask. One would be that as a result of these 2 factors, that the bid should be rejected, all bids should be reopened, so that there could be fair competition, and also that the award should be delayed for some time, that this board can feel reasonably confident that it's actually getting the benefit of the bargain, and that this 5.8 doesn't turn into potentially 10 somewhere down the road. And I guess potentially a third option would be that, in addition to rebidding, that Spinello be disallowed from rebidding due to the conflict of interest that we've cited in our bid letter to you. One thing that I don't think has been mentioned that probably is worthy of being mentioned, in the invitation for bid, it's my understanding that there is a conflict of interest provision, and I don't think that's been taken into account. Here's, again, very briefly, larger contract with Itron. It's for the installation of smart meters throughout Baltimore City and certain parts of the county. Spinello is the subcontractor to Itron in this larger contract, and they do the installation work. So if the contractor goes out to a particular site, sees that a smart meter can't be installed, then what's created is basically a repair list. The repair list comes back to the city. The city is then obligated to go out and make these meters in such fashion, or repair these meters in such fashion that then these meters can be worked on. So what Spinello has is this, basically what they're doing, or what they're being permitted to do under the old contract, and now by virtue under this water contract 1223, there's a repair list that's being created based on their going out and assessing whether or not these meters can be installed with the proper smart devices. So they have a distinct advantage in knowing which repairs are needed, where the prevalence of these repairs are, whether they're city versus county. Of course, if they're here in the city, that's going to increase certain costs associated with traffic control and repavement and what have you, as opposed to the county, which may not bear some of those costs as well. And those are the sort of things that couldn't be anticipated in responding to the invitation for bid by any of the other contractors. That's in part why you have this huge disparity as far as the amounts of money that are being bid on the project. So those are a couple of distinct issues I think the board should really be concerned with. And again, this is really an issue of public confidence. We all know that this is a very important contract. The city is hurriedly trying to bring itself into, we might as well say, the 20th century, and then we'll jump into the 21st century once we're capable of doing that. But at the same time, while it may be tempting to look at the numbers and say, hey, we're getting a really great bargain for this, the truth of the matter is there's more to the story than actually meets the eye. And let's level the playing field. Let's give open and honest information to all of the contractors so that maybe the city might benefit from an even better proposal, a better thought out proposal, and save itself money, not just in the short term, but months and years down the road.
Mr. Shapiro, normally any bid that comes in below the engineer's estimates, you guys normally have a problem with, right?
We evaluated these bid results.
Okay. Well, all three of them came in below the engineer estimates. So my question is, why are we allowing them to come in below the engineer estimates when we know that they bid low and then come back with the extra work orders to make up for the rest of the money? I've historically voted for the low bidder all the time because I believe that we get the best bang for our buck. But I've also questioned the cost overruns on these projects. 42% below the estimates with Spinelli, 29% below with R.E. Harrington, and 23.6 with Metra. Can you explain?
Yes, these bids, these on-call contracts, these are repetitive. We have bid these out multiple times. In the case of Metra, they've been working on as an on-call contractor on these previous contracts. So
on these meters?
On these exact meters. The key point is that all these bidders have prior knowledge of our system. All three bidders have been working for the city either on these particular on-call contracts or on other on-call contracts working on the same exact systems, repairing meters, putting vaults in, repairing services. The bid format is a line item format. It's not a lump sum for a fixed amount of work. So the review of the bids included us looking at the lump sum, or the line item costs for the various items so that we could determine if there was reasonableness. When you compare the results and the fact that the firms all have prior knowledge with previous work with the city and that they are not in control of the work itself directly, meaning the on-call getting referred work from the Itron sub, that gave us confidence that these bids were reasonable given the fact that the bids were repetitive over the last year. We've made almost, this is the fifth bid, same scope.
So in other words, is there a conflict with all three?
It's not a conflict. We don't believe it's a conflict.
Well, they're saying it's a conflict. So, and you're saying that they have knowledge as well.
Yes.
So,
for example, there are 150,000 locations which have not yet been scouted. None of the bidders know what work is going to be required on those 150,000.
Okay.
The conflict could be turned around in the case of Metra, for example. They have knowledge of the fact of what they've worked on up till now, based on what has been referred. Spinello, having made those referrals, has no knowledge of what has been repaired and what hasn't been repaired. We have examples where work was referred for repair by Spinello, but when it went through the quality control process with our third party, we turned that work down because it was determined it didn't require any repair work, and that work was returned back to Itron, so installation. An example, the one particular service call was turned over as needing work, but the code for it was actually that a car was parked on top of a meter vault. That doesn't require any repair work, but yet it was referred back as a location. That was caught in the normal process. There are numerous examples similar to that where work was referred back, but it was determined by our third party that it really didn't require work. Those two examples, both for Metra or Harrington or for Spinello, lead us to believe that there is a balance here, that it is not a conflict of interest. Rather, they all have generic knowledge of our system.
Okay.
Good morning, members of the board. My name is Robert Harrington, R.E. Harrington Plumbing, president. Under Itron's contract, Spinello has a list that's given to him, a route sheet, that has 2,000 plus meters every week, so he knows exactly where he's going. Prior to bidding this contract, the other 4 bidders didn't have any information on where the meters were, how many locations were we supposed to go to. Spinello had this information in advance because he's Itron's contractor. So any given day, Spinello and the other subcontractor, REI Draco, breaks up to 20 to 30 services a day. And when the services are broke and people don't have water, they got to be fixed. So that's not delayed. You have to go and fix it. So either DPW, Metro, myself, or Spinello has to fix the service. But under this new contract, Metro is out, I'm out, and now Spinello is the only guy that's fixing it. So if he breaks it and he has 30 people, homeowners out of water, that won't be delayed. He has to fix that. It might be delayed a couple hours, but somebody has to put these residents back in water. He has knowledge of this, I don't. So if I'd have had this list prior to bidding, then yeah, I could have lowered my numbers a little bit. I know where I'm going. Metro know where he's going. Spinello, he has this knowledge. He knows exactly what locations to do, city and county.
Mr. Shapiro, does that give him an unfair advantage?
No, it doesn't. I refer back to my previous comment that there are 150,000 locations that have yet to be scouted. And those 150,000 locations far exceed a daily list of a few dozen locations that may be determined to need repairs.
I'm sorry.
Yeah, just speaking to Mike.
I'm sorry. There's also a situation that exists where anything that is a default by Spinello is covered by the Itron contract. In other words, you can bid lower if you know you're not going to have any kind of downside to what you do. That's a contract that DPW has not taken into consideration in determining whether or not there is a conflict. In other words, if the timelines are not met by Spinello, then they obviously have a deal with Itron that they are paid for those defaults under the contract. A clear disadvantage to any other bidder in this process.
Madam Mayor?
So I have just a general question about the way the contract is set up. Is it true that the contract allowed for multiple contractors to respond to broken water meters, and now that it is just one company, Spinello? And if so, why was it changed?
It's not set up to limit the number of contracts. We have multiple contracts in force. Where we are right now is that the rate at which the work was being done on 1307 and 1308, these are 2 separate on-call contracts that were bid simultaneously. We awarded them. In this case, Metro was successful on both of those contracts. And both contracts were being serviced by one contractor only because they were the low bid and they were awarded. But they provided sufficient crews so that between the 2 contracts, they were able to provide services. We are in the process now of putting out an additional pair of contracts because we know that we need, based on the percentage of returned locations, the agency needs more on-call contracts in order to continue and get to the point where we can go live as planned later this year. These on-call contracts are set up for open competition. There aren't that many contractors who are experienced and interested in this type of work. In this case, we have all 3 of the primary contractors who pursue this type of work.
Well, my only problem is that they all are below the engineer's estimate. I have a real problem with that.
The experience and familiarity with our system, that matched up with the fact that we've gone through these bid cycles multiple times, has allowed, I believe, and on behalf of the agency, that the contractors have demonstrated what we expect, is that they sharpen their pencils.
Well, let me ask you this question then. When other contracts are below the engineer estimates, what do you do?
We review, in the case of a line item type bid, we look at each of the line items and reference it to the engineer's estimate. In this case, the line items are relatively straightforward. We have a lot of history on these. And we don't see where the numbers are too low. In fact, what we saw originally was the bids were very high on the first cycle of bids. And that was one of the things that made us change how we formatted the bid. Instead of putting all the large and small meters in one contract, we changed the documents to have small meters in one contract and large meters in others. The nature of the work's different.
Madam Mayor?
So I just want to sort of summarize what I hear from you to make sure that we're all on the same page. First, when this type of on-call contract went out the first time, the bidders came in higher, if not significantly higher, than the engineer's estimate.
Yes, ma'am.
After that first round, when the engineer's estimate was made public to the board, the contractors, the next time the bid went out, the contractors responded, and it was much more in line with what was previously published as the engineer's estimate. Correct?
Yes.
Now what we're seeing is now that there has been the bids coming in at or near the engineer's estimate in order to try to win the work. Now they're even going further, and all of them are bidding under what the published engineer's estimate has been in the past.
Yes.
And they're all it's following the same trend. They were all above, they were all even. Now they're all under.
Yes, ma'am.
One of the problems we got now, even when DPW puts the next set of contracts out, Spinello's going to go lower. I mean, what's to stop them from going 60% of the engineer's estimate? And normally in the past, DPW had that threshold. Normally it was 25 to 30%. So normally when it gets below that, they kick it out. He's 42, so when the next round come out, what's acceptable? That's what I want you to tell us today. Tell me what's acceptable.
You're asking the board, and we have to ask.
Yes.
Can you respond to that?
The most appropriate response is that it's a free bid process, and the bidders have in their hands the decision of how to pitch their bid based on what they know to be the work. This type of work is, in most cases on small meters, it's relatively straightforward work. It's something it's been since the beginning of the system.
So my question is, again, what is DPW floor limit on low bids? Does it exist in writing?
I think that, if I may, Mr. President, the challenge is I don't think that there's a significant amount of space between the bid amounts, correct?
Yes.
So I understand your question, how low is too low, but basically all of y'all are going low together. So the question then is, how low are you? Yes, it's the question of how low would we accept, but if low is relative and all of y'all are saying you could do it for less, you all are answering that question.
No. What I'm asking is, normally in the past, it was normally 25 to 30%. If you was below that, they threw the bid out and went to the next bidder.
So what you're saying is, how low can you go?
Right.
But what I'm saying is that happened. That is a potential trigger. It doesn't necessarily mean that the bid is unacceptable. The estimate could be off, and the way to determine that is by what the contractors are willing to do the work for, and it is different if there's an outlier. If there's someone who bid 60% under engineer's estimate and everybody else maybe did 20% or even to the estimate. But if everybody is bidding 60% under the engineer's estimate, the question then becomes, is the engineer's, should we accept that as the true value or the true cost for doing the work? If the people who were in the business together say that they can do it for cheaper.
I think if we'd have had the same information that Spinello had from Itron, it would have been a different outcome today. If we'd have knew exactly where he was going, he's the installer, he knows where he's going every week. Whether it's 2,000 or 4,000 location, he has the list. The rest of the bidders don't. So if I know where I'm going and I can position my crews, I can go low too. The problem ain't low. I just need to be efficient in what I'm doing. So if he has the list, he know where he's going. He can position his crews any way he wants. But the rest of the bidders didn't have that information prior to bid time.
So why is that irrelevant? You're saying that having the list is irrelevant due to the fact that in the future there's 150,000 more. So why is that?
That's exactly the point.
Why?
None of the bidders knows where the 150,000 are, and
No, but what he's saying is, if he had the list,
he has a partial list based on a weekly roll-up of work that's been scouted.
so why
or
wouldn't
to be scouted. It's not given out en masse.
right? So why wouldn't that daily list help the other bidders? Or why?
It's the order of magnitude. A 2,000 locations does not mean 2,000 repairs.
Right.
The recycle rate is roughly, it was estimated to be about 1.5% of the locations may require some sort of repair work. So if you look at the percentage of the 150,000, the universe of repairs is roughly 1.5 to 2%. I mean, that's the experience we've had. None of the bidders have access to location. Spinello as well. They don't know where the vast majority of locations which have yet to be scouted, they don't know what they're going to find when they get there.
Spinello has been working with Itron for over a year. He's done over 100,000 meters. All of the meters that he couldn't fix, that he couldn't locate, that Metro didn't fix, which is an Itron system. You can go in the system and pull up the system, and it tells you exactly what's open in Itron system. I don't have knowledge to that. Metro maybe has a little knowledge to that, but he's not the installer, and the other two contractors don't have knowledge to that. So prior to bid time, Spinello is averaging 2,000 to 4,000 locations a week. So if I had that knowledge on where I was going, then yeah, it would definitely affect my bid.
Can I ask a question?
Yeah.
I don't have that knowledge.
So it seems to me, Mr. Chair, that we have a number of issues that have been presented here today that we need to review. And I'll say my request is for us to be able to take a look at this information in a more in-depth way over the next week. I just want to make it abundantly clear that my request to you to defer it has nothing to do with the requests that have been made by the protestants, because I do not support the basis for their deferment. I would ask that we be able to address some of these issues that have been raised in a more in-depth way.
If we're going to defer consideration on the merits of the protest and the award, I would ask that the elected members of the board resolve the conflict issues directed against the Director of Public Works and the city solicitor, so that we can put that behind us and not have to return to that next week. And Director Chow and I can both know whether we are or are not a participant in the ongoing conversation. Either decide it or ask Harrington to withdraw that part of its position and request today.
Harrington will not withdraw that
Then I
part
would
of
ask that
its
the board decide.
position, and it certainly is fodder for any judicial review as well. Thank you.
Of course, everything that you say is fodder for judicial review, but I would ask then that the board decide that issue today.
All right. I'll take a vote on the motion to defer for 1 week.
I move that we defer the motion, that we defer contract 1342 for 1 week.
Okay, so you second.
Oh, did he? Who made the
I asked for
motion?
motion. You just.
I can't move because I've been because the protestant has moved that I be recused, and the protestant has moved that the Director of Public Works and his designee be recused. That's why I asked the board to decide those demanded recusal motions now, so that we can participate in the deferral motion and can participate next week when it's coming back.
Okay, so who you made this?
I made the motion.
I'll second.
All in favor say aye.
Aye.
All opposed nay. Ayes have it.
Thank you.
Defer for 1 week. Okay, the second item on the,
I would ask that we consider the recusal request because that will impact the way that we're able to answer these questions. Yeah, because if the board votes that there is a conflict of interest, that will impact how we're able to proceed in getting the issues resolved over this next week, unless I'm missing something.
Yeah, and I would point out that the basis for the recusal motion, at least as far as the city solicitor was concerned, was that we were rendering legal advice to the department and others before we came to the Board of Estimates. So we're now in a situation where if this issue is not resolved today, we are, I guess, precluded from rendering legal advice to DPW or the members of the board between now and next week for fear that it's going to cause a renewal or a continuation of the recusal request. And the same is true for Director Thompson. If well, it wouldn't be Director Thompson, probably Director Chow. So can Director Chow participate in ongoing discussions over the next week without fear of having that participation be grounds for his recusal next week? No.
Mr. President and Mr. City Solicitor, and all due respect, Harrington will waive and hold harmless any participation by any member of this board pending your last resolution. In other words, we believe that the participation would benefit the issue and will not press it until we return here 1 week from today.
Well, that's why he asked if you would withdraw your motion.
It's conditionally withdrawn, but it is not withdrawn for purposes of any subsequent action that we may take.
Why don't you just withdraw it and ask that you have the ability to raise it in the future, because this is really getting complicated and unnecessarily so.
Madam Mayor, I take your decision, your suggestion, and do adopt it. Thank you.
Thanks.
all in favor say aye.
Aye.
All opposed, nay. The motion carries. The second
May
item.
we be excused, Mr. President?
Yes.
Thank you.
The second item on the non-routine agenda can be found on pages 98 to 99, item 5 to 6. Recommendation for contract award rejection, SC 914, improvement to sanitary sewers and low-level sewer sheds. Will the parties please come forward?
Morning.
Good morning. All right.
Good morning. Michael Mullen with the Law Department. There's been a request to withdraw the bid of AM Liner. We've looked at that and we believe that the bid cannot be withdrawn. The complaint that was filed by AM Liner says that Comar applies and has a 90-day rule. Comar does not apply. We've talked to the state. We have correspondence from the state that says the 90-day rule is not applicable here. And our charter provides at Article 6, Section 11H1, Roman numeral 4, that all bids, once they're filed, are irrevocable. The Green Book doesn't change that in any way, nor could it, in fact, because the irrevocable nature is in the charter itself. So with that in mind, we do not believe that this bid can be withdrawn.
Okay.
We asked
You have
for...
to state your
I'm sorry,
name.
Michael Wadding with AM Liner East. Sir, we asked for correspondence back from the city in regards to our withdrawal of our bid. We did not receive that from the Department of Public Works. To be honest, at this point in time, I would like to review that statute that's within that.
It's actually, it's in the charter, and there is, are you saying that you asked the Department of Public Works?
That's in the two letters that we submitted, yes, that we asked for correspondence back regarding this withdrawal, and we received none.
So let me ask a question. How many contractors bidded on this contract?
There were 3 bids received.
Okay, 3.
Pardon me, I'm sorry, Art Shapiro, DPW. We received bids from SAK and from Spinello, as well as Amliner.
Okay, and Amliner won the bid.
Yes, they were 83.39% of the engineer estimate. The next bid was from SAK at $18,717,000 at 96% of the estimate, and Amliner, Spinello was the high bid of the 3 and they were just about 1% over the engineer's estimate.
So my question is, why do you want out of the bid?
During that period of
A
time.
bid that you won.
No,
I just wanna know.
simply put, during that period of time, the reason the 90-day award limit exists under the state statute is that we are actively bidding work up and down the northeast corridor along I-95. We've secured a lot of work during that period of time that we must now execute, and that is why we asked to be withdrawn from this.
Is that because you just don't have the necessary resources to complete the work?
Yes.
Capacities.
No, we have the capacity within the city under our capacity statement when it was submitted to the city. As you're aware, we have to fulfill a capacity statement. to
Are
the
you
city.
saying you no longer have the capacity, or are you saying, or
After
you?
that 90 days, sir? No.
Madam Mayor.
The concern that I have is that the bid process is a serious process.
Yes, ma'am.
And when respondents treat it like a crapshoot, it makes it less serious.
Right.
You know what you're doing. You bid a whole lot of work.
Yes, we do.
You either bid a lot of work that you can do, or you bid a lot of work that you can't do.
Yep.
Either of which is not our problem. This is a serious process. You made a commitment, and I've heard no reason not to hold you to that commitment. I think if you want to withdraw this bid, I think we should consider it. But in doing so, you should also agree not to bid in Baltimore anymore.
I can't do that at this time, ma'am. Reason, again, it's not a matter, when we filled out our capacity statement, which we were was required in the 90-day period and submitted it to the city, we were able, but after that 91st day, we didn't know what was going to happen. We didn't know if we were going to get the
Neither
work.
does anyone else who bids.
No, I mean, typically, as these matters are handled, there's correspondence and communication on that 91st day saying, can you please extend this award period?
Well, but as it's been explained to you, we are not, under city rules and city charter, governed by the 90-day rule. We have a charter which has been in existence longer than you and I have been in existence. It gets amended every now and then, sometimes well, sometimes not so well. But this one's been around for a long time, for as long as you've been doing business, and it says bids are irrevocable. And that's something that your company should, as a sophisticated contractor up and down the East Coast, should be aware of.
Understood, sir.
And
I'm calling for a motion because I don't see any reason why we should not hold Amliner to this contract. They bid it, won it fair and square, and I'll entertain a motion.
I moved.
I'm sorry, and I'll renew. I mean,
I understand.
if you want to say that you will no longer bid in Baltimore, I would entertain that.
I can't say that at this time.
Okay.
ma'am.
Well,
I would
entertain the
move
motion.
that we deny the protest and proceed with the award as recommended to the low bidder recommended by the Department of Public Works.
Second.
All those in favor say aye.
Aye.
Ayes has it, so ordered. Thank
For
you.
your time.
The third and fourth item on the non-routine agenda can be found on pages 112 to 121. Department of Housing Community Development. Report on the fiscal year 2013 single audit findings for the low-income home energy assistance program and Department of Audits. Okay. Okay.
I think you're
If it was-
presenting the audit, right?
No, we're responding to their report to the board.
Okay.
Well, I think, I can keep it simple, that we understand that there were some deficiencies in some of the files, and that's, we had hired an outside contractor to review and try to get additional information. They did, in fact, gather a certain amount of information on various files. Some information was not, they were not able to track down because of the age, they were talking about 3 years back, and some of these families have actually moved to other places and so forth. I don't want to get into a detailed, discussion about individual cases and what our contractor found versus the review. I will stipulate to the fact that there were some deficiencies in some of the files. But what I do want to point out is that none of the information that was originally in the files and none of the information that was collected subsequently by the outside contractor would indicate that somebody was ineligible. There may be files that are incomplete, but there's no indication that that people were ineligible. And so what I think we need to do is to move toward the recommendations, which are how to tighten up the process going forward. And so our outside contractor has made a series of recommendations, and I would say that those recommendations, together with, to the extent that they're not fully covering the recommendations of the audit department, that the audit department's additional recommendations be integrated or added to those, I should say, and that we work with the energy office, which is no longer under the housing department, but still obviously within the city government, to ensure that those protocols are put in place moving forward. So I don't think there's a big debate about what we need to do going forward. My only other point that I'd like to make is that we did mention that 24 of the files were missing related to a flood in the building. To me, that's an act of God, and and about 2/3 of the value of the awards that were given. There's a mention of $44,000 worth of question payments to clients. 28,000 plus of that is for those files that were destroyed through the flooding. That is close to 2/3. Again, an act of God does not constitute that somebody is ineligible to receive. We are ready to accept and to work with the Mayor's Office of Human Services, which now runs this program, the implementation of all the recommendations, again, made by the audit department and made by our outside contractor. We do firmly believe that extrapolating from this number of cases, again, when 2/3 are due to an act of God, there's no evidence that they're not eligible, to a figure of $6.2 million of question cost is something that is not a realistic extrapolation. Again, that does not mean that we don't accept the recommendations. We just feel it should not be characterized as $6.2 million of question cost or questioned eligibility. To not protract this any further, we are fully prepared to work with the department that now runs this program to implement all the recommendations.
Okay.
Okay, Bob McCarty, City Auditor, Department of Audits. Good morning.
Good morning.
The director did say, the Housing Commissioner did say that, I'm sorry. Okay, the Housing Commissioner did say that no evidence was found that they were ineligible, but the requirement under the grant is that adequate supporting documentation be maintained. That's what we based our finding on.
And I agree on that. I'm saying that there were deficiencies in some of the files, and I agree that you have to have the adequate documentation, and that's why we need to implement these new protocols that you've recommended and that the outside contractor has.
And did I understand you to say that a significant number of the deficiencies were attributable to the act of God causing the flood and
the dollar value, as I calculated, 28,000 plus out of 44,000 of question cost, which is close to 2/3,
right,
are due to an act of God. Yeah.
We were aware.
Unfortunately, happens a lot these days.
We were told of the flood. We have procedures we have to go with in extrapolating. We did recommend in our audit report that HHS be contacted, the granting agency, to resolve this.
And we're prepared to do that, whatever steps need to be taken.
Well, I have a couple of questions.
Yeah.
I have a couple questions. On October the 28th, 2015, you stated that DHCD had engaged Clifton Larson Allen to assist in addressing the findings, and that your department would report back to the board in about 30 days. How long did it take the outside auditors to perform their review, and what did it cost?
You want?
Hi, this is Rainbow Lin, Chief Financial Officer for the Housing Department. Yes, the contractor did take a little bit longer, and for the complication of, because the applicants are more than 3 years old, and many phone lines were disconnected, and the addresses could not be traced, and therefore it did take longer than 30 days. The contract was procured by the city of Baltimore, and the value is less than $20,000, and they have not billed us for the entire amount, and we actually believe that the value of the work is going to be less than the contract award.
So what funds are going to be used?
It will be used by the DHCD general fund.
So if it's above 25,000.
No, it's less than.
No,
20,
I said, but there has it been completed? The review?
Work is completed now.
And it's under 25,000.
Under 20.
Under 20. And when will these recommendations be implemented?
Well, as I indicated, the program is no longer operated by the
Right.
Housing Department. We'll have to work with the current administrator of the program, and I'd have to defer to them.
Good morning, Lori Cunningham, Director of the Community Action Partnership. Most of the things that were noted by the outside auditor were those things that were already observed once the program was transferred to us, and we've already begun doing some of those changes. We're working with the state doing an electronic content management system so that every piece of documentation that is brought in by the applicants would be scanned and maintained electronically, so therefore we would no longer have to worry about the storage issue. We've also done a separation of duties as far as the accounting is concerned. All of the accounting is done at the administrative office, so that part is separated as well. And so I believe most of the things will be addressed going forward.
Okay. When did the scanning start?
We're working with the state now, so it's an ongoing process. The state launched a Maximus program about a year ago. It was not widely used throughout the state. It was used by DSS, so that should be implemented within the next, I'd say, 3 months.
Also, I had requested in April, April the 29th, 2015, that it be reported back to this board the progress and the communication that was made with HAS. You said you were going to do that just now. So back in April, it was requested that you report back to the board, and
I think we've been reporting back periodically over time on a range of issues here.
No, I'm talking about with communication with HAS. That was my request.
So that's the state, right?
No, that would be the Fed.
The federal.
I don't think that, I think it would have been premature to reach out to them until the audit was completed. And so now, I assume the audit will now be closed out, and we can, working with the folks who now run the program, we can reach out to the state of Maryland and then HHS. I think the protocol is to work through the state. They receive their funding from the federal government, HHS. So if I gave any indication otherwise, I apologize. The proper protocol would be to go through the state to HHS.
So I would like you to report back to the board your communication with the.
I respectfully would say that would be the department that now runs the program, because we won't be in that process at this point. But yeah.
So we've been working with the state the entire process. All of the applications that are under question have already been reviewed and approved by the state as being acceptable. But we will continue to work with them and bring back a response within the 30-day period.
From the state or from the federal?
Which one are you requesting?
I want the federal.
Okay, we'll work with the state now and have the response from the feds within 30 days. Thank you.
Just to clarify, what was approved by the state? I'm sorry.
Just the review of the applications. The applications were already deemed acceptable by the state.
The one we're talking about here?
Right, prior to the audit finding. During the normal application process, when they're reviewed by the state, they've already looked at them and determined that all applicants did qualify for the program. However, once the audit began, we've been working with them and making sure that they're knowledgeable and abreast of everything that's going on during the auditing process, and they provided you some supporting documentation as well.
They provided, I don't believe we got anything.
Remember, this has been quite some time ago in the original response to the audit.
From the state?
Yeah. No, we
We'll
received.
send that again today. Yes.
I know there was some documentation from the state regarding the eligibility of applicants who came from outside the city, because it's a
Yes, we do recall that.
It's a
yeah.
statewide program, not a city program, and they did indicate that was not a problem. And they also indicated that there were no duplicate payments. They were not concerned about that, and I'm not sure about that other piece, but
Yeah.
I'm sure that this can all be clarified.
Okay, but was it provided to?
This is what I'm talking about. The piece that was just mentioned.
Oh, okay, not the 51. Okay, not the
Okay,
folder,
so again, I defer to.
Sure.
Okay.
Okay.
Any more? Any other?
No.
Okay, the findings and responses have been noted.
Thank
and,
you.
30 days, you will come back to the board with those responses. Thank you.
Thank you.
Okay, there have been no more business before the board. The board will recess until bid opening at 12 noon. Thank you.
Good afternoon. The Board of Education is now in session for the receiving and opening of bids. I have the following addenda to read. WC 1242 Brown Pond Dam Breach. Please change the bid due date from February 24th to March 9th, 2016. Excuse me. GS 15813RR. MEQ Building Envelope Improvements. Please change the bid due date I guess from February the 18th. I'm sorry. I don't know what the due date this one is. I don't see it. It's not here. Oh, they didn't send it up. Okay, okay. I'm sorry. Again, this is GS 15813RR, MEQ Building Envelope Improvements. Please change the bid due date from February 24th to March 2nd, 2016. Those are the addenda for today.
Hearing no objection, so ordered.
Excuse me. Sorry, I'm trying to number 2. B50004467. Supply and deliver water dispensers and bottled water to various city agencies. A bid bond is not required. DS Services of America, Inc., $160,194.74. Thank you. Thank you. Okay. I need to reread that to correct it. I apologize. Excuse me. DS Services of America, Inc., $160,194.79. Thank you. Excuse me. Holder Enterprises, Inc., $508,000. Excuse me. Nestle Waters North America, Inc., $210,194.59.
Refer these bids to the Bureau of Purchases for tabulation and report. WC 1183, replacement of Loch Raven Dam Environmental Operation Facility. A bid bond is required if the amount is over $100,000. WM Slosser Company with a bid bond. $9,933,000. Yes, it is. I'm sorry. James W. Ansel, Inc., with a bid bond. I don't know if they finished right. No, they didn't finish right. See, I'm gonna try to read this. I know. And that's my favorite. Well, this is the building control, so. See, sometimes they'll say, but the bit behind this, that may have helped me.
See, on their copies, they didn't fill in every sheet on their
Okay.
copies.
That's what we had. Imagine they did that. I think they did these. What they'll do is that they'll refer to law to the agency, and they'll have, you know,
Send it to the agency.
yeah, tabulate it. If it comes out to a number. Yeah. With a pencil. Excuse me. Excuse me. Excuse me. Excuse me. Thank you. Thank you so much. Excuse me. All right. I make a motion to refer the bid of James W. Ansel to the Law Department for review.
All in favor, say aye. Aye.
Aye.
The matter having been moved and seconded is referred to the Law Department for review.
Then the vote bad. American Contracting and Environmental Services, Inc., with a bid bond. $9,900,000. J. Vinton Schaefer and Sons, Inc., with a bid bond. $9,686,800.
Refer these bids to the Department of Public Works for tabulation and report.
He'll repeat it. Yes, he'll do it. Yes.
$9,686,800. Yes.
Are we still in the middle of this, or is this over?
We're still in the middle, still reading.
I'm sorry.
That's
Didn't mean
okay.
to interrupt.
No, you're fine. This is another bid, though, so if
Right.
you're not required to stay if you don't need to, sir.
The question I have is, I'm with James W. Ansell.
Okay, you have to ask us afterwards, sir. We have to finish the bid process. Okay, thank you. Mhm. Okay. B50004483. Remove and replace concrete pavement at Baltimore Convention Center. A bid bond is not required. C&N Associates LLC. $113,581. Boulevard Contractors Corp. with a bid bond. $249,763. E&R Services, Inc., $275,000. Excuse me. Allied Contractors, Inc., $248,350. Santos Construction Company, Inc., $210,000. Let's put this on this one. Try it. This one here is better. Nope. I'll just try to make sure, because I don't know how you know which one it is. Oh, they have in the back. Great, good. All right, good. All right, we're okay. I was afraid it didn't have a name on it somewhere, but it does. On the back, they wrote their name. Oh, sorry. Sure. M&F Contractor Company, $114,700.
Refer these bids to the Bureau of Purchases for tabulation and report.
Okay. There being no further business, we are adjourned. Thank you.